Welcome to this module on Introduction to International Environmental Law. So before we move on to the substance of this module, let's first have a brief overview of what we are trying to achieve out of this module. The purpose of this module is first to provide basic information on sources of international environmental law, and second, mapping of the development of international environmental law in its historical as well as contemporary context. And the third major purpose of this module is to introduce major events, international environmental law conferences that contributed to the development of international environmental law. And the overview of the module is, first we will have a brief discussion on the historical development of international environmental law, and this discussion will be followed by again a brief overview of what are the major sources of international environmental law with some illustration on examples. And the third part will be, we will be discussing on major international conferences that had contributed to the development of international environmental law. And the fourth part of this module will be a brief overview of institutional mechanism with a special focus on the contemporary approach. The fifth part will be an introduction to a critical approach towards international law that will capture a brief introduction to the North-South debate, which is considered as a critical approach towards analyzing international environmental law. Now, before we move on to the substance, let's have a brief overview of the context. That means why we need an international legal framework to deal with environmental issues. First of all, let's first take a brief mapping of what are the major problems affecting environment in general. There are several factors, so I will just point out some of the few major issues or major reasons or major causes of environmental issues at the international level. First major issue is the Industrial Revolution. Industrial Revolution means Industrial Revolution requires indiscriminate use of natural resources. It also leads to, or it also results in, inadequate and improper disposal of waste, and both these factors result in significant environmental problems. And another major cause of environmental issue is agriculture, because mainly when I say agriculture, it means use of pesticides and other chemicals, including persistent organic pollutants that are being used for increasing agricultural production. And a major part of these chemicals which are used in the agricultural productions are going back to the environment and creating a lot of problem, including pollution. And the third major factor affecting our environment is changing lifestyles and consumerism, because nowadays we use a lot of equipments and instruments, especially for example electronic instruments like refrigerators, air conditioners and mobile phones, and given the way we use extensively these instruments or equipments, and given the way we discard many of these equipments, that creates a lot of environmental problems. So altogether, the current situation is that we are facing a kind of environmental crisis, and this crisis actually led to what we call as emergence of environmentalism, both at the international level as well as at the national level. So when I say at the international level, see, there are several path-breaking moments, and which is arguably started in the 1960s and early 1970s. So I will just point out some of the major path-breaking moments that led to the emergence of what we call as environmentalism. And one is this famous book called Silent Spring by Rachel Carson, which was published in 1962. And this book was about the implications of pesticides used for agricultural purpose and how it affects environment and public health. The second major path-breaking moment was another book called This Endangered Planet, which was published in 1972 by Professor Richard Falk. And together, among many other books and works and reports, these works together provided a kind of warning on impending environmental crisis, or the existing environmental crisis, and the likelihood of a huge environmental crisis coming up in future, and the ability as well as, and these works also warned the ability as well as inability of the international community to address these issues. And at the national level, for example, in India, we had this Chipko movement in India, and which happened in the hill state of Uttarakhand in the early 1970s. This movement was led by a local population which was against deforestation or cutting of trees by individuals and companies. And altogether, I mean, these movements in the 60s and 70s that contributed or that triggered the emergence of a kind of environmental consciousness, or an effort to make the international as well as the national community aware of the environmental disaster in the pipeline or the impending environmental crisis. And this is the crisis or the context in which we are discussing international environmental law or environmental law in general. That means first we will have a brief discussion on why we need environmental law at the international level. Of course, I mean, as I had already mentioned, we are facing an environmental crisis due to various reasons. So the question is, and at the level in which this environmental crisis is going on, which is unlikely to sustain, or I mean, we will be unable to face this problem we will be unable to address this problem in the near future. In that case, as a matter of taking anticipatory actions or actions in anticipation, or to put it in a different way, we are supposed to take some precautionary actions. So what kind of roles environmental law can play in taking these precautionary actions? So in that case, I mean, definitely it is agreed, or there is no dispute on this part, that environmental law can play a significant role in addressing many of these problems, at least diluting the implications of this problem or mitigating these problems in fact. But the question here is, since the focus of this module is exclusively on international environmental law, first we will discuss why we need an environmental legal regime at the international level. Because there are a couple of important reasons why we need environmental law at the international level. For example, many of the environmental problems we are facing now is global in nature. When I say global in nature, means its sources are also global in nature, its implications are also global in nature. Sources of all environmental problems come from every nooks and corners of the world, and people or environment at all parts of the world are also affected by what we call these environmental issues. Because of this reason, I mean, because these implications and sources are global in nature in most cases, what we need is some global efforts, or to put it in a different way, we can't address this problem just by focusing on domestic measures. Domestic measures in its own capacity are insufficient to deal with some of these global environmental issues. Let's look at the examples of climate change. Sources of climate change, because almost all countries are producing carbon, and at the same time almost all people or environment, all corners of the world are affected by the phenomenon of climate change. So none of us are free from its sources, none of us are free from its implications. Same is the case with another major environmental problem called ozone depletion. We all contribute to this environmental problem, at the same time we are all affected by this environmental problem. Similarly, the case with protection, the issue of protection of migratory species. There are several animals and birds, they migrate to different parts of the world. There are several birds which crosses several countries. For example, Siberian kraits come to Rajasthan during the winter season after crossing 5 to 7 countries. So these birds and animals, they do not respect political boundaries. So if we want to protect some of these species or organisms, then we need international cooperation, and this kind of international cooperation can be worked, or international environmental law can be the framework that facilitates this international cooperation, or it can lay down various rules and institutional mechanism for the protection of these environmental issues or various species. So that means this explains what kind of a role international environmental law can provide or can play to address some of these major environmental issues which are truly global in nature. On top of that, nowadays international environmental law also considers several environmental issues which are traditionally considered as domestic in nature. But considering the huge or indispensable interlinking between the environment, so all kinds of domestic issues also have some kind of international implications. For example, the case of biodiversity. Any impact on biodiversity in any country that can have impacts upon the global environment. So that means whether it is truly of international nature or of exclusively a domestic issue, international environmental law is critical or significant in both these contexts. So we will be discussing some of these major environmental laws and as well as the role played by these environmental laws in addressing some of these issues. Before we going into the details or the substance of international environmental law or environmental law instruments, let's first have a brief overview of what are the legal developments in the historical context. When did this environmental law begin? Or what was the context in which this development of environmental law started? Or whether the development of environmental law, whether international environmental law is a recent phenomenon, or it has been already it has already been there ever since the human civilization started. But many of the standard textbooks on international environmental law, they cites mid 19th century as the major sources of development of what we can call as modern international environmental law. So in that context, some of the early developments has focused on conservation of wildlife. For example, Convention between France and Great Britain relating to fisheries 1867, Convention for the Regulation of Whaling 1931, Convention to Protect Birds Useful to Agriculture 1902. So these are the few examples of international environmental law in the early historic context. But when we look at some of these instruments, it's quite clear that these instruments followed a piecemeal approach. When I say piecemeal approach, because look at the focus of these instruments. All these instruments essentially focus on some minor part of the environmental issue, say for example conservation of wildlife. Or if you look at the third example, Convention to Protect Birds Useful to Agriculture 1902. And this is all about protection of birds useful to agriculture. So that means essentially the developments in the early period was following a piecemeal approach. It never followed a comprehensive approach addressing all kinds of environmental issues. It never seemed to have accepted or recognized the essential link between different species and environment. So in that way, this was a kind of limitation of environmental law or environmental law in its early period. But later on, another major landmark in the historical context is what we know as Trail Smelter case. This was a case between Canada and United States, and this arbitration case was decided in 1941. And this case was about fumes emerged from or escaped from a smelting industry in Canada, and it caused some damages in Washington in the United States. So the question was, what kind of liability can be fixed on the industry, or to put in a different way, what kind of liability can be put on Canada for what they caused as environmental damages. And this is considered as a landmark case. Arguably this is an important case where an arbitration tribunal introduced this concept called state responsibility in the context of transboundary pollution. And let me just read out an important paragraph from this Trail Smelter case, because in this case the tribunal held that, I quote, "No state has the right to use or permit the use of its territory in such a manner as to cause injury by fumes in or to the territory of another, or the properties or persons therein, when the case is of serious consequences and the injury is established by clear and convincing evidences." There are a couple of points to be emphasized from this case. First, it clearly lays down a rule that no country has the right to cause injury to persons or property in another country. And if it happens, that particular country is liable under international law for such environmental problems. So, to conceptualize this is a case laying down an important rule on the state responsibility in the context of transboundary pollution. And the reason why this case is considered as landmark, because this principle of state responsibility in the context of transboundary pollution has found its way in several documents adopted subsequent to this case. And this principle was followed by various courts and tribunals, including the International Court of Justice in various cases. So, in that way we can safely conclude that the trade smelter case and its principle of state responsibility in the context of transboundary pollution had great influence on the subsequent development of international environmental law. So, while these are the few landmarks, what we have seen in the last few decades, especially since 1970s, is a dramatic or rampant dramatic expansion of international environmental law, especially since the Stockholm Environmental Conference 1972, that we will discuss a little more in detail. So, before going into that, let us have another major part, like what are the sources of international environmental law, because by this module students are expected to be aware of what are the major sources, so that they should be able to identify the sources and analyzing it. So, as regarding the sources of international environmental law, we have an immediate reference to a provision in the Statute of International Court of Justice, that is Article 38 Clause 1. Article 38(1) gives an indication of what kind of sources the International Court of Justice can rely on when they have to decide, when the court has to decide a case, or when the court has to identify a law, where can the court look into for sources. So, in that way Article 38 Clause 1 is generally regarded as the sources of general international law, and which is equally applicable in the case of international environmental law as well. So, as per Article 38 Clause 1, the major sources of international law, or to rather international environmental law, are treaties, customs and general principles of law recognized by civilized nations. And another major source is judicial decisions and teachings of the most highly qualified publicists. But there is a qualification for the second source called judicial decisions and teachings of the most highly qualified publicists, because these sources are regarded as subsidiary sources. That means the first set of sources which I mentioned, that is treaties, customs and general principles of law recognized by civilized nations, these are considered as the primary sources of international law, and that makes judicial decisions and teachings as secondary sources. So, we will briefly discuss what are the major treaties in the context of international environmental law, and how these customs are also relevant in the case of international environmental law. Treaties. So, what is a treaty? To use a layman's kind of definition for treaties, treaties are legally binding agreements, and in the context of international law, treaties are legally binding agreements between countries. There could be many kind of treaties. For example, treaties could be bilateral in nature, regional in nature, as well as or multilateral in nature. Bilateral means an agreement between two countries. Regional means an agreement between countries in a region. For example, if countries in South Asia come together and enter into an agreement, that can be called as a regional treaty. And multilateral means this is an agreement between countries from different regions, or it could also be called as a kind of global treaty, because it almost all states or several states are party to these agreements. So, as far as treaties are concerned in the context of international environmental law, what we have seen is a proliferation of what we can call as a proliferation of multilateral environmental agreements since the 1970s. Multilateral environmental agreements means several countries from different regions, they entered into an agreement to address one or more environmental issues. So, we will be identifying or we will be discussing some of the major features of these multilateral environmental agreements with some examples. Let me first put some examples to get an idea of what are these treaties. For example, there is this treaty called Convention on International Trade in Endangered Species 1973, International Convention for the Prevention of Pollution from Ships 1973, Vienna Convention on Protection of the Ozone Layer 1985, Basel Convention on the Control of Transboundary Movements of Hazardous Wastes and Their Disposal 1989, Convention on Biological Diversity 1992. These are the few examples, and there are innumerable number of treaties relating to or in the context of or addressing different environmental issues. So we can try, let's try to identify some of the common features or approaches from these examples. We can see that all these multilateral environmental agreements, they are following a kind of issue based approach. All these treaties address a specific issue. Say for example, Convention on International Trade in Endangered Species, which is also known as CITES. It addresses a specific issue, or it regulates international trade in endangered species. It identifies a set of endangered species, and then it facilitates cooperation between its parties to regulate international trade so that these species are these species do not get extincted. Similarly, the Ozone Layer Convention, Vienna Convention on Protection of the Ozone Layer 1985, and this also addresses a specific issue, and we can find innumerable number of examples, whether it is protection of wetlands or protection of migratory species, the issue of climate change, issue of transboundary air pollution, so on and so forth. So the essential characteristics is most of these treaty regimes, they address a specific issue. And the recent trend is, because last couple of decades, or at least since 1970s or 70s and 80s and 90s, we have seen a kind of proliferation of multilateral environmental agreements. A number of agreements have been adopted addressing different issues, ranging from wetlands to species to climate change to biodiversity and whatnot. But recently, of late, we have realized that mere adoption of international treaties or multilateral agreements is not sufficient. So recently, the shift has been changed significantly to the issue of implementation of existing treaties. So what we can say is, or what we can understand from this phenomenon is, the recent trend is not about adoption of different treaties. Instead, the recent trend is about how to ensure better implementation of existing treaties. So let us try to identify some common features of multilateral environmental agreements, because this module does not seek to give an elaborate description of each and every treaties, which is not possible. So what we are doing right now is to identify some of the common features of which we can see in almost all multilateral environmental agreements. An important feature is that all multilateral environmental agreements lay down obligations for state parties. Say for example, the Biodiversity Convention 1992, it lays down obligations to take measures for the protection of biodiversity. Another major important feature is it designs or envisages institutional mechanism for implementation of the treaty, because earlier many of these environmental treaties used to rely on existing environmental institutions. Say for example, several environmental treaties used or still using United Nations Environment Programme as its institutional mechanism for implementation. But recently the trend has been changed, and nowadays multilateral environmental agreements are not using existing international organizations or institutional mechanism. Instead, they introduce, or recently these multilateral environmental agreements introduced a novel idea called Conference of Parties, which will come back to this issue or this phenomenon later. A third important feature is financial mechanism. Some of these multilateral environmental treaties introduces or envisages financial mechanism to facilitate or enhance the implementation of the treaty, or implementation of the rules envisaged under the treaty. For example, the Ozone Convention. Ozone Convention established a financial mechanism called Ozone Fund. The idea of this financial mechanism was to assist developing countries to meet their obligations under the convention as well as under the Montreal Protocol adopted as part of the convention. And the idea is majority of these environmental agreements, or look at the obligations which countries are supposed to fulfill under these environmental agreements, and it's quite clear that many of these obligations, if these countries want to fulfill these obligations, they require human resource, a lot of money and technology, which many of these developing countries are lacking, or especially these least developing countries are do not have these facilities. So it is very important that all multilateral environmental agreements should have this kind of mechanism, so that all countries are able or capable of fulfilling their obligations. Otherwise, obligations will remain on paper, and if this is one mechanism or one way to address the capability of state parties to fulfill their obligations under multilateral environmental agreements. The last important point is, what are the major advantages of multilateral environmental agreements? Why we have seen a certain explosion of multilateral agreements in the last 4 or 5 decades? So what was the major reason why we rely on multilateral environmental agreements to address our environmental issues? One important advantage is, this is state parties can come together and frame or adopt a treaty. So that means this actually ensures, or this facilitates the ability of the international community to respond to emerging situations. First of all, majority of these environmental issues are uncertain and which requires significant scientific support. That means scientific evidences, or it requires first international community to understand what is the problem in the light of scientific evidences. So as and when the scientific evidences emerge, these multilateral environmental agreements equip the international community to address that issue without wasting too much time. This could be considered as an important advantage of multilateral environmental agreements in addressing environmental issues. The second one is, as I already mentioned this advantage, that it equips international community to respond to the emerging scientific evidences. Say for example, we still are not 100% sure about many of these environmental issues, including climate change. So our responses or the regulatory tools and regulatory measures should be according to the emerging scientific evidences or according to our latest understanding. So this multilateral environmental agreements and its flexibility, which enables international community to address these issues as and when they get, scientific, more and more scientific evidences, as and when the international community is and becomes more aware of these issues, its root causes and the possible alternatives or solutions. The second major source of international environmental law, or rather general international law, is custom. So what is a custom? A custom is a practice which has some legal effect, which has a legal effect. So that means custom means it is state practice plus that legal effect, which in legal terminology called as opinio juris. It means that the custom is a practice followed by states. Custom in international law or international environmental law is a practice followed by states, and when the state follow that practice, they think that they are legally obliged to follow that practice. So if we combine both these elements, if both these elements are there, for example state practice and this element called opinio juris, that particular practice can be considered as a customary practice or customary law or customary rule. So what is the advantage of this customary rule? Customary rule means it doesn't have to depend upon any formal agreements. For example, that means it creates obligation for all states. So there are several things, for example, if there is a global custom, a universal custom, all state parties are expected to follow that custom, or that kind of rule is binding upon all state parties. There is only one exception which is recognized under international law, is like this, that exception is that kind of customary rule is not applicable to a state if that particular state has persistently objected to that particular practice. Otherwise, this kind of customary rules are binding upon all state parties, irrespective of the fact that whether they have entered into an agreement or not. Like treaties, there are also different kind of customs. Customs could be universal in nature. Regional customs are also recognized under environment in international law. There could be bilateral custom, that means there could be custom between just two countries. In that cases, that particular customary rule is not applicable to other states. Similarly, there can be a custom at the regional level. In that case, that particular customary rule is applicable to that countries in that particular region. But there can also be a universal custom which is binding upon almost all states. The only exception could be this what we call as persistent objector. However, what kind of role this customary rule or custom has played in terms of the development of international environmental law, as the standard textbook says, like customary law rules have played only a secondary role in international environmental law. That means still, since international environmental law is relatively a new entry in the field of an international law, therefore and the kind of issues they are addressing, because the kind of issues they are addressing, the development of law cannot wait for long. As far as customary rules are concerned, it will take long time to evolve or concretize a customary rule. So that kind of time duration is not available in the case of many environmental issues, because many environmental issues demand immediate action. So that could be one reason why custom still remains as a secondary, or custom still plays a secondary role in international environmental law when compared to treaties. Now the important issue is how we can identify customary rules. There are different sources. For example, one way is to look at various documents where state parties might have repeatedly asserted some rules. For example, one good example of this kind of customary rule is state responsibility for transboundary pollution, which was explicitly recognized by an arbitration tribunal in the Tail Smelter case. Later on, this was recognized by the International Court of Justice in various cases, for example the Corfu Channel case, and later on from Stockholm Conference onwards, this particular principle has been repeatedly recognized in various instruments. So this could be considered as one proof that almost all states, or at least majority of the states, agree upon this particular rule. So this could be one important, or one reason to consider this particular rule as a customary rule. And another major source of identifying, or the way to identify customary rules, is to look at the cases. Various courts at international level and the tribunals have identified various customary rules. For example, the rule of the procedural rule of environmental impact assessment. International Court of Justice identified or declared this as part of customary international law in a case called Pulp Mills case in the year 2010. Similarly, this reasonable and equitable utilization of shared waters, and this was also recognized as a customary rule, or at least an emerging customary rule, by the International Court of Justice in Gapsikovo-Nagimoro's case in 1997. So that means it is irrelevant whether these principles, whether it is environment impact assessment or the principle of reasonable and equitable utilization of natural resources, or particularly shared water resources. So these principles do not require any particular agreement to establish that these are binding international law rules. Instead, by recognizing these as, or by identifying these as customary rules by the International Court of Justice, this will be considered as part of customary rules, and when we consider something as customary rules, this is binding upon almost all states, unless a particular state or states have been a persistent objector in terms of these rules. In addition to these treaties and customs, we also have several other instruments which are non-binding in nature, but still they play significant role in the development of international environmental law. First of all, there are several other terminologies. For example, the most prominent terminology that is being used in the context of this non-binding instrument is called soft law. This is the origin of this word is as considered as it's opposed to what we call as treaties and customs. For example, treaties and customs are binding, legally binding in nature, whereas these soft laws are non-binding in nature. Or at the most, what we can say is these soft law instruments are of persuasive in nature as opposed to legally binding in nature in the case of treaties and customs. So what are these non-binding instruments? This could be a General Assembly resolution adopted by for example, the United Nations General Assembly resolution. This could be a resolution passed by a major international a conference on environment, or this could be a document adopted by a non-governmental organizations. For example, the Helsinki Rules on the Uses of Waters of International Rivers 1966, adopted by the International Law Association, and this document has been so influential in the development of international law on international rivers. So that means some of these non-binding instruments, even though they are non-binding, they are quite influential and they are quite significant in terms of understanding international environmental law. So what are the benefits? So how do they influence? So what are the benefits of these non-binding instruments? One important advantage of these non-binding instruments are because they influence the future development of international environmental law. For example, the same Helsinki Rules on the Uses of the Waters of International Rivers 1966, adopted by the International Law Association. This document has been significantly influential in the development of law on international rivers, and later on, when the International Law Commission was entrusted with this duty of developing a document on international rivers, they relied on this document significantly. Or to put in a different words, Helsinki Rules was the starting point for the development of what we now have, this document called 1997 Convention on Non-Navigational Uses of International Watercourses. Or another major advantage is repeated assertion. No matter whether this particular soft law or non-binding instrument has eventually culminated into a binding treaty, but repeated assertion of a particular principle in a number of non-binding instruments, that may lead to the concretization of that particular rule as a customary rule. One good example, as I have already pointed out, is the state responsibility for transboundary pollution. So that means these non-binding instruments we need to, or international environmental law students need to consider or need to take these non-binding instruments extremely seriously, because they play an important role in the development of international environmental law. Or many of those rules which are relevant, extremely relevant in the context of international environmental law, we can find it in non-binding instruments, or at least they played crucial roles in the development of that particular rules, or at least in the context of concretizing that rules. Now let us move on to the next important part of this module, that international conferences on environment. The reason, an important question to start with is why we need to take international conferences on environment seriously. Before answering this question, let me just point out some of the major international conferences on environment. The first one is the United Nations Conference on the Human Environment 1972, which is popularly known as the Stockholm Conference. The second one is the United Nations Conference on Environment and Development 1992, which is known as the Rio Conference. World Summit on Sustainable Development 2002, which is known as Johannesburg Summit. And the fourth one is the United Nations Conference on Sustainable Development 2012, which is known as Rio Plus 20. Now the question, let's go back to the first question, like what are the roles played by these international conferences, or why an international environmental law student should take these international conferences seriously. First, let's try to identify some of the major contributions made by these international conferences in the development of international law, environmental law, or framing international environmental law rules. For example, many of these soft law instruments or non-binding instruments adopted in these conferences, they highlight key principles of international environmental law. For example, Stockholm Declaration. Principle 21 of the Stockholm Declaration talks about state responsibility for transboundary harm or transboundary pollution. Principle 22 and 24 of the Stockholm Declaration details about liability rules in the context of environmental pollution or environmental harm. So now look at the contributions made by these principles, or this document called Stockholm Declaration. These documents, which arguably took its origin from the Trail Smelter case, and subsequently it was repeated in all other important non-binding instruments on environmental issues. So that means many of these non-binding instruments or adopted under these international conferences, they play significant role in concretizing certain rules or principles of international environmental law, for example the state responsibility for transboundary pollution. A second major contribution made by these international conferences are they bring lots of countries together on a common platform to discuss environmental issues, and this may also lead to arrive at a political consensus on different environmental issues. It doesn't matter whether all these consensus lead to the adoption of a binding treaty, but still political consensus itself is very significant as far as the future course of actions are concerned. A third major contribution is many of these international conferences identify different environmental issues for future considerations, or it identifies emerging environmental issues. And another major contribution is it facilitates adoption of multilateral environmental agreements, because many of these international conferences introduces draft documents or draft treaties, and in many instances it leads to or it led to the adoption of multilateral environmental agreement, that means legally binding treaties on various environmental issues. Important examples are Climate Change Convention, that is United Nations Framework Convention on Climate Change was adopted in the Rio Conference. Similarly, the Biodiversity Convention 1992 was adopted in the Rio Conference. Another major or landmark contribution made by these international conferences, or a significant change introduced by these international conferences, are the participation of non-state parties. And this requires a little background, because international law traditionally involved only sovereign states. Non-state parties were alien to the international law making process. In that way, looking at it from that angle, in majority of these international conferences, especially from Rio Conference onwards, it marked significant participation of non-state parties, especially NGOs working on environmental issues. So in that way, it facilitated participation or contributions from non-state parties in the international law making process or international environmental law making process. And this could be considered as a revolutionary change in the field of law making process at the international level, because a domain which used to be exclusive for state parties has now become opened for non-state parties as well. And indeed, these non-state parties are playing significant roles in shaping the environmental law regime at the international level. Another major part of this module is the institutional mechanism, which I highlighted earlier, that there are different kinds of institutional mechanism. For example, one could be an independent institution, say in the case of United Nations Environment Program. Several multilateral environmental treaties depend on this institutional mechanism for their better implementation. And these traditional IGOs, I mean, nowadays this is not very attractive in the case of institutional mechanism for multilateral environmental treaties. Partly the reason is these traditional intergovernmental organizations are very expensive to maintain, and they are also bureaucratic in nature. These are the reasons highlighted in the literature on environmental institutions. In this context, this led to a novel idea of institutional mechanism for better implementation of international environmental law. This is known as Conference of Parties. Conference of Parties, the idea is to have a conference of parties for each multilateral environmental agreements, and this conference of parties, this institutional mechanism is expected to meet regularly to evaluate the implementation or assess the implementation of the treaty, as well as the possible changes that are to be made or additional documents to be prepared or additional documents to be implemented. So it in effect it satisfies or it carries out almost all functions a traditional intergovernmental organization used to do. And to highlight another point, there are very few multilateral environmental agreements concluded since 1972 rely on existing intergovernmental organization for its implementation. Instead, they all follow this idea of Conference of Parties as an institutional mechanism for the implementation of that particular multilateral environmental agreement. Let me highlight some of these functions of this Conference of Parties. I may quickly go through some of these functions, like it can establish subsidiary bodies, it makes arrangements for meetings of all state parties, adoption of rules of procedure for itself as well as for subsidiary bodies, providing guidance to subsidiary bodies and secretariat, adopting new protocols, ensuring implementation of and compliance with these multilateral environment agreements. And the subsidiary bodies are also extremely important in the context of environmental issues, because many of these environmental issues are emerging in nature. So probably in the environmental law or its approach has to change or modify according to the new scientific evidences. So in that case, the subsidiary bodies or technical bodies are extremely relevant for better implementation of environmental treaties. So in that way, this flexible or evolving nature of institutional mechanism that helps a lot for a better implementation of multilateral environmental agreements. Now the last important point in this module is to introduce a critical approach towards international environmental law, and this is to look at it from a north-south debate. And this debate is built upon an assumption that all countries are not sharing a common concern, or to put it in a different way, different countries have different interests and different priorities. For example, these industrialized countries, while they advocate for conservation of the environment or protection of environment, developing countries and least developed countries, they argue for more developments. This was quite evident in Mrs. Indira Gandhi, the then Prime Minister of India, during the Stockholm conference, that she highlighted this poverty as a major problem, whereas the industrialized nations highlighted protection of environment as an important issue to be considered. So that means different countries follow different interests and their concerns and priorities are different. While some countries focus on protection of environment, mainly industrialized countries, economic development is a major concern for developing countries. And this is reflected in its worst form in the case of climate change law. For example, in the case of the ongoing negotiation or discussion on the United Nations Framework Convention on Climate Change and the new protocol that is to be adopted, or that is supposed to be adopted under this UNFCCC. Here the problem is, while industrialized countries are arguing for more emission reduction, developing countries are focusing more on economic development that automatically will have more carbon emission. So it's all about a debate on the degree and the extent of liabilities under this climate change law that all countries are supposed to take, or whether there could be a differential degree of international law responsibilities that the state are supposed to follow. And the result of this north-south debate or north-south differences is development has become a major part of environmental discussion, or as some literature cites, international environmental law has by and large has become international law of sustainable development, where the discussion or the discourse on development is, or economic development is, an essential part of the regime. So that means in different countries, these differences in some cases which is justified because of difference in the degree of economic development in various parts. In some cases it creates real impasse in some of the major issues like climate change, where the international community is supposed to take serious immediate actions. So to summarize, what we can see is international environmental law has expanded in its scope dramatically. So what we have seen is international environmental law started from a limited focus on conservation of species, and now we have n number of international treaties covering a range of issues. So that means it has really expanded in its length and breadth. However, even though we have a number of treaties, most of these treaties or some of these treaties are facing serious problem in terms of its effective implementation. So currently the focus is not exclusively on adopting more and more treaties. Instead, the focus of international environmental law regime is how to ensure effective implementation of existing treaties. The last point to be emphasized is, even though environmental issues have been recognized as important issue for international community to address, still the international community could not manage an international organization on environment. Even though there are several literature and scholars have been arguing for an international environmental organization, the international community so far could not manage that. This is a critical point in the context that international community has managed to set up an organization for international trade, or for that matter many other issues. Still, even though environmental issues are extremely relevant, we could not manage an international organization to facilitate cooperation and better implementation of multilateral environmental agreements. Thank you.